a missed court date, a bonding company bails out, and a man ends up in an attic. Buckle up. This courtroom roller coaster starts now.
Talba.
Yes, sir.
You had something you wanted to do about this?
Yes, sir. Mr. Dodson opposes the removal of the bonding company from his bond. He wanted to state his reasons for that. He had his testimony, the substance of it today, Your Honor, would be that my office gave him the wrong court date. It appears that he had been provided the 12th of February as his court date rather than the 10th. On the 10th, there was court in session, Your Honor. On that day, he was not present, and that resulted in the failure to appear capias being issued, and then I think that's what probably led to the bonding company's motion, which is understandable. However, he did get, his testimony would be that he received incorrect information, that he came to court on the 12th and was told on that day that he was not on the docket.
So Dodson claims it was a clerical mistake. Wrong court date given, but the bonding company says he vanished and had to be pulled from an attic. Who do we believe here?
So that would be the basis for his explaining his failure to appear that day in court, and the basis for his respectful opposition to relieving the bonding company in this case.
Let's let Mr. Thomas come up and we'll see what he has to say about it. So. Thomas, you've heard what Mr. Talbot says on behalf of his client as to the reasons why he says he missed the court date. Do you have anything that you want to state?
Yes, sir. Yes, sir. He missed court in this sections. He came in a day or two later on another court date that I was here. I sat beside him, Mr. Dodson, told him that he had missed court previously, a day or two prior. He gets up, he tells me he's going to his car to get the paperwork. He never comes back.
All right.
I go to, once I receive the CIRFA, I go looking for him. I find him at a residence on CCC Road. He gets away from me that evening. A few weeks later, I find him at the same residence. I contact the Dixon County Warrants Division. They send 4 officers there.
Asterisk, yep, you heard that right. Officers literally found him hiding in an attic with another wanted man. That's not exactly the behavior of someone eager to clear their name.
They find Mr. Dodson hiding in the attic, along with another gentleman that had warrants in the county. They finally took both of them into custody.
All right. I've already granted the motion to withdraw from the bonding about a bond, and I'm by no reason to deviate from that decision. Thank you.
Thank you, Your Honor.
I believe we had already set Mr. Dodson 9/22.
Thank you, Your Honor.
I'm going to deal with that one first. In docket number 2022 CR 311, he's charged with violation of probation. It's indicated he's going to admit the violation, waive a hearing, and be revoked to serve the sentence with credit for time served. In docket number 2023 CR 436, I have a document indicating he's going to plead guilty to an amended charge of attempted aggravated child abuse, a Class B felony, receive a sentence of 8 years to serve at 100%, suspended after he served 1 year day for day.
What do you think? Does pleading guilty to attempted aggravated child abuse deserve more than just 1 year served? Drop your take in the comment.
That 100% is the release eligibility, but he'll serve 1 year day for day and then be released to probation. This will be served consecutively to the prior case. Mr. Owens, raise your right hand. Let's place you under oath. Thank you. You can put your hand down. State your full name. Put your hand down, but you can state your full name for the record.
Eric Michael Owens.
Mr. Owens, you're here today with a charge of violation of probation as well as a new case. I want to deal with the violation of probation. Waive your right to a hearing and to a trial and to an appeal by entering a plea of guilty according to this agreement. You understand this is going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir, I do.
How do you plead then as to the charge, the amended charge of attempted aggravated child abuse?
Guilty.
All right. Do you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if it is found that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yeah, my sir.
Anybody forcing you to do this?
No, sir.
Do you understand I cannot accept your plea unless I'm satisfied there's a factual basis for it and that you that you are in fact guilty? You understand that?
Yes, sir.
This baby overdosed on opioids while under the care of 2 adults, and one of them, Mr. Owens, who fled instead of getting tested. That fact alone sealed the deal.
Then I will ask you, I've already asked you if you're guilty, and you said you have what?
State's going to lay the facts.
All right, that's fine. State.
Judge, if this case went to trial, the proof would be that July the 17th of 2023, the victim, who was an infant at that time, was in the care of Mr. Owens and the child's mother, Brandy Noble. Miss Noble has already pled and entered a proffer in this case. While in their care, custody, and control, the baby overdosed on opioids and had to be Narcaned by the hospital. It was during that time that the mother tested positive for some of those drugs, and Mr. Owens was not able to be drug tested because he fled from the scene.
All right. I'm not asking that you agree with those facts, but you understand that's what the state's evidence would be at trial. You still wish to plead guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir, I am.
Feel like Mr. Locker's done a good job of representing you competently?
Yes, sir.
Mr. Locker, do you know of any reason you should not enter this plea?
I do not, Your Honor.
Anything further from the state? Then Derek Michael Owens in docket number 23, CR 436, upon your plea to an amended charge of attempted aggravated child abuse.
Escapes to child abuse convictions, this case was stacked with emotion and chaos. Subscribe for more courtroom breakdowns, and don't forget to hit the bell.
I find you guilty, sentence you to 8 years Tennessee Department of Corrections. That will be a release eligibility rating of 100%. But it will be suspended after you serve 1 year day for day and will be served consecutively to your violation of probation case, which I just entered a judgment on. Thank you.
Thank you, Your Honor.